The law requires a list, 6 providers, 4 of which have to be doctors. You have a right to a second opinion off that list if you don't like the doctor you saw. And most importantly, with regard to panel doctors, is that, or company doctors, is that the regulations that come from the Department of Labor and Industry specifically forbid an employer from controlling your choice of the doctor. So they can't just tell you, go here, go to WorkNet, this is where you go. You get to pick where you go. And then when you go there, that doctor is in a doctor-patient relationship with you. And you have all of the rights, and he has all of the obligations that any doctor-patient relationship has. And even the company doctor list is only for 90 days after the injury. Once 90 days comes, you can go to anybody you want to go to and still submit the bill to them to be paid. You know, and one last thing on that is that the only penalty for not going to one of the company doctors, and it's a big penalty, is that they don't have to pay for the medical. It doesn't mean your claim's dead. It doesn't mean that your claim is over because you didn't go to even a doctor off that list. It just means any doctor you saw during that 90 days for the work injury, they don't have to pay for. What we suggest a lot of times folks do after an injury is during that 90-day period. You're in that 90-day period, we got to get the list. The other thing, the penalty for the list is if they don't have a list, you can go anywhere you want and they have to pay for it. And we will fight for anybody who's in that situation. During the 90 days, if they publish a list, if you're treating with a company doctor during that 90 days, there's nothing that stops you from making a wellness visit with your family doctor. Not a visit about the work injury, because he won't be paid and probably won't see you for the work injury. But during that 90 days I suggest that people go in and get their pressure checked, maybe go in and just talk about whatever little cough you might have had, or just want to go in for a general wellness visit. And what's the first thing your doctor asks you is how you're doing. So when he asks you how you're doing, you say, not so great, along with wanting my pressure and stuff checked with you. 2 weeks ago, I got hurt on the job and boom, 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 all this happened. I got all this pain and I'm treating with the company doctors. It's a good place to go to have your version of how you were hurt recorded by a doctor who's loyal to you. He can't treat you, but he can comment on the treatment that you're getting, and he can tell you, and he can record in his medical notes what you said about the injury and what your complaints were. That can be very useful to us in court later on. You have up to 120 days to provide notice. They have an obligation. This is really important. This is something that I hope everybody leaves here with and remembers, that they have an obligation to respond in a very specific way after you provide notice of the injury. After you provide notice of the injury, they have 21 days to let you know if they're accepting the claim as work-related or if they're denying the claim, with a notice of compensation payable if they're accepting it, or a notice of compensation denial if they are denying the injury.